Afternoon. We'd like to start today's session with the officials from the Department of Foreign Affairs, Trade and Development. In front of you, and before I do that, I guess what I'd like to do is at the end of the meeting keep you for about 5 minutes to go in camera to just talk about a couple of issues that we're working on that we need to have a quick conversation about. It won't take long. So pursuant to the order of reference of Thursday, April 14th, 2016, Section 20 of the Freezing Assets of Corrupt Foreign Officials Act and the statutory review of the Act. Before us are the witnesses from the Department of Foreign Affairs, and it's Mark Glosser, who is the Acting Assistant Deputy Minister, Europe, Middle East, and Maghreb. And Mark, what I'd ask to do is maybe you could introduce for the record all of your colleagues that are in front of us, and then I'll turn the floor over to you for your presentation. And colleagues, it's a little bit longer of a presentation, and that's good, a little more detailed. And then from there, we'll go right into a series of questions. Mr. Glosser, I'll turn it over to you.
Thank you very much, Mr. Chairman. Perhaps it would be quickest, given the change in job titles, for each of my colleagues to quickly tell you who they are and their job titles, starting on my right.
Sure.
Sarah Taylor, Director General for Northeast Asia and Oceania, and that includes DPRK.
Alison Leclerc, a Senior Arctic Official and Director General for Circumpolar Eastern Europe and Eurasia, and that includes Russia.
Hugh Edsett, Legal Advisor and Director General.
Marc-Yves Bertin, Directeur Général des Politiques Économiques Internationales.
Marc-Yves Bertin, Director General of International Economic Policy.
Thank you very much. Good afternoon, and thank you to the committee for inviting my colleagues and me here today to provide further information and to respond to your questions on the Special Economic Measures Act, CEMA, in relation to three specific countries: Iran, the Democratic People's Republic of Korea, and Russia. My colleagues and I represent a cross-section of expertise within Global Affairs Canada related to Canadian sanctions and the three countries highlighted for further discussion today. As Acting Assistant Deputy Minister for the Middle East and Europe, I have been asked to make the opening remarks on behalf of Global Affairs. Avant de parler brièvement de chacun des pays,
Before speaking briefly on each country, I would first like to take the opportunity to acknowledge the letter dated November 15th, 2016 from the Honourable Chair, Robert Nault, in which more specific information is being requested on a number of items.
We will endeavour to provide the committee with a written response to bullets 1, 2, and 8 from the letter, while the remaining requests will be touched on in my opening statement. My colleagues and I would, of course, be pleased to respond to those or any other questions you may have after the statement. Russia. En ce qui concerne les sanctions que le
Turning to the measures that Canada has enacted against Russia, I will take this opportunity to respond to some of the questions posed by the Chair.
Protests of November 2013 and the subsequent flight of President Yanukovych in February 2014, the Ukrainian province of Crimea was invaded. Within days, Russia reportedly had more than 6,000 troops in Crimea, and Ukraine appealed to the international community for help. Before turning to Canada's sanctions regime against Russia, let me first highlight the assistance that Canada provided to the Ukrainian government under the Freezing Assets of Corrupt Foreign Officials Act. Following a request in writing from the Ukrainian government, the Governor and Council determined that the Ukraine was in the midst of a complex political transition due to economic weaknesses inherited from the former government and unilateral intervention in Ukraine by Russia. The Governor and Council also determined that it was in the interest of Canada's international relations to enact regulations freezing the assets of certain allegedly corrupt individuals associated with the former government of Viktor Yanukovych under FACFOA. As a result, FAC 4 regulations were enacted on 5th of March 2014, freezing the assets of 18 individuals. By March 14th of 2014, Russia had increased its military presence to an estimated 20,000 troops and had taken control of key institutions and facilities, including the legislature. The Governor and Council found that the situation constituted a grave breach of international peace and security that had resulted or was likely to result in a serious international crisis. As a result, the Special Economic Measures Russia regulations and the Special Economic Measures Ukraine regulations were approved on March 17, 2014. Au cours des semaines et des mois qui ont suivi, Affaires mondiales Canada.
In the weeks and months that followed, Global Affairs amended the Russia regulations 13 times and the Ukraine regulations 11 times to keep pace with the situation on the ground. In all cases, across the sanctions regime, amendments were made to the regulations to adjust the measures, to better target the sanctions, or to mitigate unintended consequences. This is an ongoing process that continues throughout the life of the regulation.
The CEMA allows for the imposition of particular measures, not only the foreign state, but any person in that foreign state or its nationals that don't ordinarily reside in Canada. Most CEMA regulations, save for the DPRK, include what are typically referred to as the, quote, asset freeze, unquote, provisions, which apply to targeted individuals and entities listed in the regulations. All regulations imposing such measures contain descriptions of the types of persons that can be listed. In the case of the Russia regulations, senior government officials, entities controlled by the government of the sanctioned state, or individuals or entities contributing to the violation of the sovereignty or territorial integrity of Ukraine are all eligible to be listed. To demonstrate that a targeted individual or entity satisfies those descriptions, officials from Global Affairs, both here in Ottawa and at our embassies abroad, monitor events on the ground, draw from academic and media reports, consult with other departments within the Government of Canada and our international partners, and draw from classified information. Il est essentiel dans le processus d'inscription de garantir.
Ensuring that we have done our due diligence in establishing the grounds for listing is key to the listing process. In addition, every CEMA regulation imposing measures on a listed person contains a provision allowing them to apply to be delisted. In such an application, the designated person can argue that they do not or no longer fall within the categories of persons that can be designated as set out in the regulations. Alternatively, the designated person can argue that his/her designation does not further the objectives of the regulation.
89 Russian and Ukrainian individuals and entities. The Russia sanctions regulations currently comprise 4 schedules that list targeted individuals and entities targeted under the sector-specific measures, and the products that are subject to restrictive measures. These were developed as Canada, along with its partners, moved beyond the initial targeting of individuals implicated in the illegal annexation of Crimea to economic measures aimed at key sectors of the Russian economy, in particular the financial, energy, and defense sectors. Canada's sanctions, along with those of our partners, are having a significant effect on the Russian economy. The combination of low commodity prices and Western sanctions has weighed heavily on investor confidence, prompting large capital outflows from Russia. President Putin has publicly indicated that sanctions are, quote, severely harming Russia, unquote, particularly with respect to opportunities on the international financial markets. The Russian Central Bank has forecast the net capital outflow for 2016 to be $53 billion US. At the G7 summit in Japan, May 2016, leaders reiterated their condemnation of Russia and reaffirmed their policy of non-recognition of the annexation of Crimea, including sanctions against those involved. The duration of our sanctions is clearly linked to Russia's complete implementation of its Minsk agreements and respect for Ukraine's sovereignty. Canada stands ready to take further restrictive measures in coordination with international partners should Russia's actions so require. Passons à Corée du Nord. La Corée du Nord.
Let's move to the People's Republic of Korea. Moving on to the DPRK, North Korea is the only country to have undertaken nuclear tests in the 20th century. It has carried out 5 tests in 2006, 9, 13, as well as 2 this year. They were just 8 months apart, on January 6th and September 9th of this year. The frequency of North Korea's ballistic missile launches has also risen sharply this year. So far, in 2016, North Korea has conducted more than 20 short, medium, intermediate range, and submarine-launched ballistic missile launches. North Korea's ongoing development of nuclear weapons and their delivery systems, which constitutes a breach of its international obligations, as well as the accelerating pace of North Korea's nuclear and ballistic missile tests, is of grave concern.
6. Acting under Chapter 7 of the Charter of the United Nations, the United Nations Security Council adopted Resolution 1718, imposing sanctions against DPRK in response to a nuclear test the DPRK conducted a week earlier, on October 9th. Since then, the United Nations Security Council has adopted multiple resolutions modifying and strengthening the initial sanctions, including Resolutions 1874 in 2009, 2094 in 2013, 2270 in 2016, in response to the additional tests carried out by the DPRK. Canada has enacted sanctions related to the DPRK under the United Nations Act and the Special Economic Measures Act in order to pressure the DPRK to abandon all existing weapons of mass destruction programs and in response to the DPRK's nuclear tests, ballistic missile launches, and to other aggressive actions. Canada implemented UN Security Council Resolution 1718 by introducing new regulations under the UN Act and implementing subsequent UN Security Council resolutions on the DPRK by introducing amendments to these regulations as required. Through its implementation of UN sanctions, Canada has imposed an asset freeze and dealings prohibition on designated persons, including both individuals and entities. The regulations implementing the UN resolutions on the DPRK also impose far-reaching prohibitions on exports and imports in a number of areas, targeting financial flows into the DPRK and seeking to restrict the export to the DPRK of materials or technical assistance that could contribute to the development of the DPRK's weapons programs. This includes bans on the exports of items such as arms and related material, aviation fuel, and provision of training to DPRK nationals in sensitive fields such as advanced physics or aerospace engineering, among others. Canada has also implemented travel restrictions against persons designated by the UN Security Council under the Immigration and Refugee Protection Act and its regulations. On August 11, 2011, Canada introduced unilateral sanctions against North Korea under CIMA, implemented through the Special Economic Measures DPRK regulations, which complement and expand upon the sanctions imposed under the UN Act and provide for a ban on all exports to the DPRK, all imports to Canada from the DPRK, all new investment in the DPRK, the provision of financial services to the DPRK and to persons in the DPRK, the provision of technical data to DPRK, and docking and landing in and transiting of Canada by DPRK ships and aircraft. These regulations were adopted following the sinking of a South Korean naval ship the Cheonan, on March 26, 2010. On that date, following an explosion in the Yellow Sea, the Cheonan sank, causing the deaths of 46 crew members. On May 20th, 2010, South Korea released the results of a multinational investigation in which 3 Canadian naval experts participated, which concluded that a North Korean torpedo sank the Cheonan and that overwhelming evidence supported the conclusion that the torpedo was fired by a North Korean submarine. Following the release of the Cheonan investigation results, the Government of Canada strongly condemned North Korea's violent act of aggression. Canada's sanctions imposed under the Special Economic Measures Act complement its implementation of UN sanctions and reinforce the message to the DPRK government that its aggressive actions, such as the sinking of the Cheonan, are unacceptable. Certaines exceptions sont possibles.
Some exceptions are possible under the regulations, notably for exemptions on humanitarian grounds, such as the export of goods, such as food, medicine, medical supplies, and so on. These are goods consigned to organizations for the purpose of safeguarding human life or for disaster relief. In its administration of the permits process, the Department undertakes evaluations on a case-by-case basis, an evaluation of the impacts of the imposition or non-imposition on humanitarian grounds of sanctions in each case when exemption to the regulations is requested. Through that process, permits have been granted in 12 instances for the export to North Korea of humanitarian goods such as food and medicine, baby formula, multivitamins, and other items.
2016, the UN Security Council adopted Resolution 2270, the latest addition to the UN sanctions regime against North Korea. Few elements of this resolution go further than Canada's existing autonomous sanctions under CIMA, which already includes a full export ban with some humanitarian exceptions. We hope that efforts to agree on a new Security Council resolution in response to North Korea's most recent nuclear tests and its ongoing efforts to advance its ballistic missile program will be successful. In the context of assessing the impact of sanctions regimes imposed by the UN Security Council, which Canada has implemented, the Department conducts internal analyses and participates in consultations with partner countries to assess the means by which the effectiveness of sanctions implementation may be improved. Canada and its like-minded partners believe that effective and coordinated implementation of relevant sanctions is and will remain critical to international efforts to pressure the DPRK to resume dialogue and abandon its nuclear weapons and ballistic missile programs. With regard to Iran, in September 2005, the Board of Governors of the International Atomic Energy Agency, the IAEA, found Iran to be non-compliant with its Nuclear Non-Proliferation Treaty Safeguards Agreement. Iran refused to suspend proliferation-sensitive activities, and the IAEA referred the matter to the UN Security Council in February of 2006. The Security Council identified Iran's nuclear program as a threat to international peace and security, and between 2006 and 2010, it adopted a series of successive resolutions against Iran and imposed 4 rounds of sanctions on Iran. The obligatory elements of these UN Security Council resolutions were implemented by Canada.
In 2010, Canada imposed the first of 6 tranches of autonomous sanctions against Iran under CIMA, in line with a broader global approach in response to Iran's nuclear proliferation and ballistic missile program. In the case of Iran, autonomous sanctions were imposed in response to Iran's continued violations of its international non-proliferation obligations, including those coming under relevant United Nations Security Council resolutions. In particular, its failure to suspend its enrichment-related and reprocessing activities, both of which are ways of producing the fissile materials necessary for nuclear weapons, as well as its refusal to cooperate fully with the IAEA.
The UN sanctions regime, applied in Canada under the UN Act and supplemented by the autonomous sanctions applied by the US, EU, and a number of like-minded countries, including Canada, played a key role in bringing Iran to the negotiating table. After lengthy negotiations, on July 14, 2015, the P5+1 concluded the Joint Comprehensive Plan of Action, JCPOA, with Iran. Under the deal, Iran agreed to significant constraints rolling back its nuclear program and subjecting it to extensive and ongoing international verification in exchange for nuclear sanctions relief. The JCPOA was endorsed by the UN Security Council in Resolution 2231. A key milestone was reached on January 16, 2016, known as, quote, Implementation Day, unquote, after confirmation by the IAEA that Iran had implemented a number of upfront commitments, dramatically reducing Iran's ability to produce the fissile material necessary for nuclear weapons. The UN, the US, and the EU then lifted or suspended their nuclear sanctions against Iran. The EU and US kept a subset of nuclear sanctions in place, which are due to be lifted in 2023, assuming Iran continues to implement the deal. The EU and US sanctions related to Iran's support of terrorism and human rights abuses, however, remain in place. Le 5 février 2016,
on February 5, 2016, in order to comply with the decisions of the UN Security Council in Resolution 2231, Canada amended its UN-mandated sanctions under the Iran UN regulations. That same day, Canada also amended the sanctions against Iran imposed under CIMA by replacing the broad ban on financial services imports and exports with a set of controls and prohibitions specifically targeting trade with Iran in sensitive products with security implications.
Canada continues to maintain a revised list of individuals and entities subject to asset freezes and with whom all transactions involving property are prohibited, and prohibitions on the export of sensitive goods listed in the regulation or related technical data. Canada also continues to restrict the export to Iran of a wide range of sensitive products under the export control list, including a wide range of items for which proposed exports require prior approval and permit issuance by the Minister of Foreign Affairs. According to the quarterly verification reports of the Director General of the IAEA, Iran is continuing to implement its JCPOA commitments. That being said, in the IAEA Board of Governors' November report on verification and monitoring in Iran, it has been noted, with some concern, by Canada and like-minded countries, that Iran's stock of heavy water slightly exceeded the JCPOA limit of 130 metric tons. This is the second time Iran has exceeded the limit it committed to in the JCPOA. According to these reports, Iran exceeded the limit by 1/10 of 1 ton or less than 0.1% of the allowable limit. Global Affairs Canada officials are continuing to closely monitor all developments regarding the Iran nuclear deal. It is important that Iran continue to fully implement all of its JCPOA commitments. Were Iran to stop implementing its commitments, UN Security Council Resolution 2231 includes a snapback mechanism through which the UN sanctions regime could be reapplied. Canada continues to have serious concerns regarding Iran's nuclear ambitions, given its history of nuclear proliferation and its ongoing ballistic missile program, and therefore maintains tight restrictions on all exports to Iran of proliferation-sensitive goods, services, and technologies, in particular those which could assist in the development of Iran's nuclear and ballistic missile programs. Au terme de cette entrée en matière,
With this outline in mind, my colleagues and I look forward to your questions. Thank you.
Sir, colleagues, we have roughly an hour and a half, so I think there's a fair amount of time to get into the weeds and talk about some of the major questions of the day. You may notice we want to review at some point the letter written to the department to assure ourselves of it, but one in particular is the question that is asked most often that will be coming to us later is the number of full-time equivalent positions that are attached by Global Affairs Canada to the administration and enforcement of Canada's economic sanctions and the associated level of budgetary resources. I assume, Mr. Glasser, this and the other two matters, we'll have a quick review of that to make sure that we can get those questions asked for us. It's one that's asked quite often by members of the committee. So with that in mind, I just want to turn it over to Mr. Kent to start with the questioning, and then we'll go through the rounds. We should be able to get through 3 rounds today. So, Mr. Kent.
Thank you, Chair, and thanks to you all for attending today and helping to lead us through some of the decision points of our study. And what we've heard from witnesses to date, from a variety of witnesses to date, is that monitoring and compliance of sanctions and detection of violations and enforcements of sanctions comes down to the responsibilities of quite a number of Canadian government departments and agencies, the resource capacities of those departments and agencies, and the willingness of those departments and agencies to prioritize sanctions enforcement or investigation. And I'd just like to refer you to some testimony we had on October 26th from John Buscariel, who's a partner and leader of the International Trade and Investment section of the McCarthy Tétrault Law Group. And he testified, and I paraphrase, but he testified that the United States represents the high water mark in sanctions detection and enforcement and compliance, and that the Canadian system is broken. He said that lacking a consolidated list, it is very difficult for commercial banks, commercial operations in Canada to know who they're dealing with or whether they're dealing with people of some risk of violation of sanctions. And he said that Global Affairs refuses to provide advice. There's a lack of advice or expertise when it is sought by the legal representatives of firms, Canadian firms that honestly want to comply and avoid any compromise of our sanctions regime. So I wonder if you could respond to Mr. Buscariel's testimony.
Yeah.
Thank you very much, and thank you for the question. On the specific question about whether the department is in a position to be able to provide legal advice to individuals who might seek that advice from the department, it is quite correct what Mr. Buscariel had to say, which is that we do not provide legal advice to the public, and we certainly have heard the comments from stakeholders on the specific question of obtaining advice from the department. I know you had as well a specific question about resources, and that was a question that was also in the letter from the chair to the department. It's one that will respond, I think, to the committee in writing in order that we can describe the best picture of the manner in which the department actually provides resources. It is a matter generally where the department is continuously, of course, reviewing its priorities and the resources that are dedicated to activities. And I think the work of this committee will be important to future consideration of those issues.
With regards to the lack of a consolidated list which is available to Canadian companies, again, smaller Canadian companies, some of them have very limited financial resources to be able to determine who they're dealing with, or when, as you say in your presentation today, when a revised list of individuals and entities subject to asset freezes is corrected or adjusted without a consolidated list, how would you suggest that companies who want to comply, or agencies that are, for example, immigration, are assigned enforcement or detection, how would they accurately and completely do their work?
This is also a question that I've noted has come up in the committee hearings as well. We don't currently have a consolidated list. It is possible to access the list in a couple of manners. One is through the department's website, where the lists are posted immediately once they become law. We also, through the website, allow any individual that wishes to get an update of the list to receive it automatically, essentially through an RSS feed as well. And so that's another possible means of obtaining the information. A consolidated list as such would be an administrative document, document as opposed to the actual legally binding text itself, in which case you always have to go back to the Department of Justice regulations to get the actual legal text of what the names, for example, would be, or what the names of entities would be.
With regards to the Russian sanctions, the public and the media have noticed discrepancies in the individuals and entities that are listed on either the American list or the Canadian list. And for example, there are three notable individuals, Sergei Chemezov, Igor Sechin, and Vladimir Yakunin, who are on the, or were on the American list and listed by Australia, Mr. Yakunin particularly as a close personal and financial associate of Vladimir Putin. He's since been demoted in the oligarchy hierarchy, apparently because his son applied for UK citizenship after establishing residency there on some of the wealth extracted from Russia. But I'm just wondering, Mr. Chemezov, in his case, was the CEO of Rostec, an industrial and military company with which some Canadian aircraft manufacturers may have had an interest. Mr. Sechin with Rosneft, which apparently owns or did own 30% of an Exxon project in Alberta. And Mr. Yakunin, president of the Russian Railways from 2005 to 2015, who apparently had some dealings with the Railway Association of Canada and SNC-Lavalin. I'm just wondering, how do Canadian business considerations figure into whether or not someone is on a list or not on a list when they are prominently on the higher levels of the U.S. sanctions list?
Russia? Well, thank you very much for the question. I can speak to that question from the Russia perspective. There may be others who can speak more generally. The underlying question, as I understand it, it relates to the coordination between ourselves, the EU, and the U.S., and how do we manage that. So, I mean, as As you can see for the number of updates for Russia and the related ones, Ukraine, 13 in one instance, 11 in another, it's an ongoing effort of due diligence that takes into account multiple perspectives. So that's the work of our missions abroad, it's the work at headquarters by officials, and that certainly includes stakeholder consultations, including with business and private sector. So we're guided, of course, by the parameters of the specific regulation. And then in terms of the due diligence, taking into account multiple perspectives. So that's kind of the systemic answer, and I'm not sure that completely answers it, but it's because it's an ongoing effort to see what's happening, what the U.S. is doing, what the EU is doing, and so we're in constant coordination with them. With respect to the three specific cases that you raise, I can't really speak to individual cases, but if there are elements that I can respond to, I'm happy to do so later if we can get back to you.
So, and I'm doing a little bit of apples and oranges here, but with regards to the Iranian nuclear sanctions, it has been suggested fairly widely that they were relaxed because European countries had greater interest in commercial ventures and connections with Iran, and that ultimately the United States had to follow along and relent in that area. And I'm just wondering whether in the case of these three, and I know you're not perhaps familiar with the specifics, but whether in this case Canadian commercial considerations can take priority over the intent of the sanctions being applied.
Well, I would say that when we look at the domestic implications of sanctions, the impact on our Canadian companies, in coordination with our partners, we do make an effort to ensure that Canadian business is not going to be relatively disadvantaged, shall we say. So that's part of the aim of coordination, so that, I mean, first of all, that the sanctions are effective, of course, and that they're targeted and that they're strategic. And part of making sure that they have impact is making sure that they operate in concert. From our standpoint, in terms of looking at the domestic impact, we would also want to make sure that, as a general rule, that our competitiveness is not unduly affected in comparison with our international partners.
Thank you, Mr. Kent. We'll now go to Mr. Sidhu, please.
Thank you, Mr. Chair. Thank you all for your testimony today. Mr. Kent did touch a little bit about the Russian sanction, but I'll be more general in my question. After the invasion of Crimea, the government of Canada placed sanctions on several Russian and Ukrainian officials. But shortly after, the Russian government responded by placing sanctions on a list of Canadian officials. Now the question comes, are these sanctions mainly symbolic, or do they have practical uses?
The retaliatory ones that the Russians have put on us? Well, that's a really good question. I must say that I'm more prepared to speak about the impact of our sanctions on Russia than on the return one. I mean, I would certainly say that in my, I have to say, 2 months in this job, less than that, dealing with Russia, reciprocity is certainly a very key principle when you're dealing with the Russia. So whenever you do something, you can certainly expect there to be a response, and there will be an effort on their part to make the response commensurate with what we have done. For more specific information on what has been the impact on Canada of those sanctions, economically and in terms of our companies, I would have to take that down and come back to you. I'm afraid I'm not in a position to answer it right now.
Okay, well then going back, the government of Canada places sanctions like these. Can you highlight what are the main goals of Canadian government is trying to accomplish when we put the sanctions to other countries?
With specific reference to the Russia sanctions and the associated Ukrainian sanctions, the purpose of the sanction is to put pressure, working with our partners, is to put pressure on the government of Russia in the face of its actions in Ukraine, in respect of Ukraine's sovereignty. So, practically speaking, that would relate to the fulfillment of its commitments under the Minsk process, and with respect to its illegal annexation of Crimea. So that is the purpose of the sanctions.
Can you highlight any changes to SEMA, the Freezing Assets of Corrupt Foreign Officials Act, that would make more effective legislation? Do you know any changes to SEMA lately? You said you've been on the job for the last couple of months, or somebody else can answer?
That's on Russia. I think on SEMA, I would refer to my.
Okay.
Sure. Perhaps I can understand the question a bit better. Are you talking about if I'm aware of or have views on improvements to SEMA? Or are you asking how has the use of SEMA evolved over time?
No, I'm more concerned about any changes have you seen?
Yeah, I mean, as a public servant, the chair will know that our role here is to explain, if you will, the how of the legislation as opposed to the what and why and whether or not we should be surfacing potential amendments to the Act. So at this point, I think it'd probably be premature for me to come and speak to you about any changes to the Act, or inappropriate for me to speak to you any potential changes to the Act, I should say.
Thanks, Mr. Chair.
Okay. Since there's still another 4 minutes left in Mr. Jetty's time, I'll go to Mr. Miller.
Thank you. Mr. Adsett, previously when you met with us, we discussed the holes that may exist in the current legislation, particularly with respect to violation of gross human rights. And it's a topic that kind of flows throughout the discussion we've been having at committee. And you mentioned that there is no perfect fit, obviously, whether it's in SEMA, FACFO, or the current legislation that exists in the criminal code. And there seems, again, to be some confusion as to where the holes are. A lot of people discuss the ability to freeze assets that are the product of crime or proceeds of crime, and that legislation exists. And then in the context of a threat against international peace, obviously the instruments under SEMA exist. Some of the concerns that have been raised are more in the nature of law enforcement, and that is probably something that, unless I'm mistaking your roles, you couldn't answer. The question then is on the hole that does exist with respect to freezing legitimate assets or the proceeds of crime, but let's focus on legitimate assets that may exist within Canada with respect to gross human rights violators. There are a number of concerns with plugging that hole, namely due process, the ability to seize those assets, again, more in the realm of law enforcement, and also the nature of unintended consequences and repercussions of the state that may be involved or backing the people that are violating human rights in a gross fashion. I want to focus on more of a legal question, and if you can't answer it, I'd be submit it to you, and perhaps you could submit a written response to the committee. But what prevents right now the minister from, by order in council or otherwise, finding that a person abroad has violated human rights in a gross, indecent fashion and freezing their assets in Canada? Again, I'm not talking about a Canadian national, I'm talking about a foreign national.
Thank you very much for the question, and let me give a caveat at the very beginning to say wouldn't be appropriate for me to try to give legal advice to the committee, but maybe I can give some information if that would be of use. I think the question that you're posing, if I can word it slightly differently, would be what would be the bases in Canadian law that would allow the minister to be able to freeze the assets of an individual who is not a Canadian national, is abroad, is a national of a foreign state, just as the broad description, I think, of the issue or the question. Currently, your basis in Canadian law would be essentially the United Nations Act, or the Special Economic Measures Act, or the Freezing Asset of Corrupt Foreign Officials Act, if you meet the criteria in that legislation. So the United Nations Act, of course, that's a Security Council resolution. Special Economic Measures Act, it could be one of two possibilities. The one that's most commonly discussed is a grave breach of international peace and security. But there's also another trigger under that act, which is essentially a resolution or decision of an association of states of which Canada is a part. That's actually how we implemented sanctions against the former Yugoslavia. It was a G7 decision or resolution. And then the Freezing Assets of Corrupt Foreign Officials Act, again, within the terms of that legislation, that's on the request of a foreign state to freeze the assets of corrupt foreign officials in the circumstances that are defined therein. But those would be the basic legislative tools that are currently available. I know that the committee also had a question, which was in a letter that was sent to the Minister of Justice, to ask for information about the suite of legislative tools that might be available, and there will be a response, I understand, from Minister of Justice to that question that may assist perhaps as well.
So if I can ask, and again, I can't afford your billable rate at my salary, so I'm glad that
you can afford it.
Providing the legal advice. But how that is or is not precluded by an order in council? Simply the minister deciding that this event has occurred and that action needs to be taken?
I think, again, without venturing into domain in which I would get into trouble, to have an order in council, you would generally need to have some kind of legislative basis or some kind of legal authority in some manner as well. So the question, I think, would be, what is the legal authority to issue that order in council?
Right. Thank you, Mark. We'll get back to you. We now go to Madame Lavadière, s'il vous plaît.
Merci beaucoup, Monsieur le Président, et merci.
Thank you, Mr. Chairman. Thank you for this very detailed presentation on 3 groups of sanctions. That said, the committee is also very interested in knowing how the system works, how sanctions are implemented, whether there are gaps in our legislation and in our systemic approach. So I'd like to begin, since we'll have time for a number of questions. I'd like to start by following up on what Peter Kent was saying. I was very pleased to hear about the cases of Mr. Sechin, Timizov, and Yakunin, since that's a file that we had raised a number of times under the former government. Now, that's my 10 seconds of politics. I'd like to continue on the issue of a consolidated list. Is there a reason why other countries have a consolidated list that's very easy to consult for small and large businesses, whereas Canada doesn't have one? Is there a practical reason for that? Don't we have the resources? Is there a legal issue? Why don't we have a consolidated list? Thank you.
The list has come up a couple of times in the committee as well. We currently don't have one. I think it's a question that certainly has been raised as well, I know, by stakeholders, and one I think on which there will be further reflection. I would say that one of the challenges with a consolidated list is that it is essentially an administrative list. At the end of the day, in order to have a fully solid sense of what the binding list is, it's necessary to return to the Department of Justice regulations or the regulations themselves. So that is one limitation on a consolidated list, is that at the end of the day it's necessary to turn back to the regulations themselves as the source of the list in the first place.
Merci, mais si je comprends bien,
Thank you. But if I understand correctly, even without a consolidated list, companies have to go back to the regulations anyway, because all the consolidated list would really do is save them a step. That's correct. Thank you. Now, going back to the wording in the regulations, other countries have legal services to help companies, especially the smaller companies who find it the most difficult to understand the regulations in all their detail and to apply sanctions effectively. Is that something we might envisage for Canada? Could such a service be provided, and if so, by which department?
I think probably goes back to this question that was posed earlier as well about the manner in which we have organized ourselves to respond to queries from the public and generally to respond to sanctions. I would say that currently we do have limits on our ability to provide advice to the public, and what we have done to try to meet the demands for advice from the public to date has been to, among other things, to make sure that we have what we hope is a clear website which is set up in a manner that is meant to make it easier, at least for small businesses and others, to be able to understand the sanctions regime, to break down the areas that we impose sanctions, not only by country, but also by the types of sanctions that are imposed. So it's a website where anybody can visit it and can click through and see what the scope of particular sanctions are. And we've tried to do it in a fairly plain language kind of approach, because I think we understand that these issues can be very complex and complicated. So that's what we've done to date so far. I think, as with other issues, though, we are taking good note of comments that have come not only previously but during the committee hearings as well.
maintenant, en ce qui a trait aux...
Now, with regard to following up of sanctions, implementation and compliance, I'd like to know who is responsible for ensuring that sanctions are implemented, who's responsible for monitoring them, when it comes to Canadian companies operating abroad. For example, the Strafe Group, which failed to comply with Canadian sanctions and UN sanctions, and which on the ground monitors the actions of Canadian companies abroad to see if they are in fact in breach of Canadian or UN sanctions. What is the process for prosecution, as it were, and for sanctioning those companies?
Response to that question without, again, dealing with specific companies or specific concerns that might have been raised. As a general approach, sanctions, the enforcement of sanctions depends on essentially law enforcement agencies. It's RCMP, and to a certain extent, a Canadian Border Services Agency as well. So if the department becomes aware of information that there are allegations that sanctions have been violated, that information can be passed on to law enforcement for them to take appropriate action. But it's very much a decision for law enforcement to make.
But how can I put it? Is it a proactive process? Is monitoring Canadian companies abroad a proactive process to ensure that they're not dealing in sensitive materials or proliferation sensitive materials. Is it proactive, this monitoring to make sure they don't violate sanctions, or does Canada simply wait to hear by some other means, the newspapers, for example, that they are violating sanctions, and then that's reported to the RCMP?
That Canadian companies operating abroad will comply with Canadian law. I think that's a general expectation and an assumption that Canadian companies will do so. And in fact, I would say I think that's probably the case in most circumstances. There are, of course, enforcement agencies, including the Canadian Border Services Agency, that can talk, I think, probably more specifically to how they ensure that Canadian exports are done in a manner that is consistent with Canadian law, including consistent with Canadian sanctions law. There's not, to my knowledge, a monitoring program as such, but certainly if we become aware of allegations or concerns, that information can be passed on to law enforcement as appropriate, and I suppose as it would be with any other matter of law enforcement as well. My colleague Marc-Yves is seeking the chair's indulgence.
Oui, non, je rajouterais qu'il y a quand même...
I would add that there are agencies with Finance Canada, particularly the Office of the Superintendent of Financial Institutions, and FinTrack, which sends information to clients, to the private sector, to keep them informed about the regulations in place, any new regulations in place, in addition to what Hugh mentioned. There are thus proactive measures in place to help the private sector remain in compliance. One very brief point for Mr. Altsett. Canadian Border Services Agency, yes, but I'll take an example. The Strait Group. These were arms produced outside Canada and sold to South Sudan, Libya, and so on. So I would imagine that there is a potential role there for global affairs to play. Sorry, I have to get used to calling it by its new name. Since we do have a presence abroad, and CBSA or the RCMP doesn't. I'm talking about Global Affairs Canada when I say we.
Use this perhaps as an additional point to make. Again, without speaking about specific cases, but when we're talking about United Nations sanctions, for example, of course there's a role not only for Canada, but a role for all member states of the United Nations. And when you're talking about complex situations and complex sanctions, there is a role for other partners to play as well.
Merci. We'll go to Mr. Miller, please.
Thank you. I want to continue on another related notion that we're examining as part of the expansion of this legislation, or considering expanding with respect to gross human rights violations. But it isn't limited to that. It's limited to individuals that find themselves often against their will on a list. It has to do with due process, and it's elements of due process that we don't necessarily think of. I mean, obviously we think of the ability of a person to appear in front of a court and get proper judicial review. I'm sure you would like a lot of these people to come to Canada to stand in front of a court so you'd actually get your hands on them. But one of the things has to do with the judiciousness of imposing these sanctions on individuals in the first place. And that is in the nature of reliable evidence gathering. The ability, as my colleagues mentioned, to, as a company, let's say a company doing business somewhere, to access a list that is maybe cohesive, coherent, or up to date, and then challenging it in a court of law. And I'd like, Hugh, perhaps you're the best person to answer this. What are your thoughts on that process as we look to sort of expanding, or at least reviewing the current set of legislative scheme?
I do think that the due process question is an important one, and I would say that it's been central to the way that we have approached sanctions in our own existing legislation to date. And you, I think, have probably heard from some witnesses who've spoken already about the United Nations process and the role of the UN ombudsperson in the sanctions delisting process in the case of United Nations Security Council sanctions. We have, I think, established means by which individuals that are on the list, who are on a list under the Special Economic Measures Act, for example, can apply to be removed from the list. And they may have grounds for doing so. They may argue, for example, that they don't belong to one of the categories that the list was established. Maybe just to give you an example, in the case of the Iran SEMA regulations, the category of persons that are listed include persons engaged in proliferation-sensitive nuclear activities, Iran's activities related to the development of chemical, biological, or nuclear weapons, et cetera, et cetera. And so certainly there is the possibility in Canadian law that an individual that believes that they are not properly on the list would apply. And if the individual is not satisfied with the reply that they get or the decision of the minister on that application, they can always potentially seek a judicial review as well. So the due process elements are important. Any efforts to establish legislation along these lines, it's very important that it contain those due process elements as well.
OK. Puis j'avais réalisé que Marc-Yves était ici. Puis je voulais poser la question. Vous n'êtes peut-être pas la bonne personne.
You may not be the right person for this question, but I'd like to ask something about what measures countries targeted by the legislation can take against us and the effectiveness of our measures against them, especially when it's unilateral. If I understand correctly, you're asking about the negative impact that the application of restrictive measures can have. What analysis do you conduct before making a decision?
Sanctions entail some obvious consequences for the target state, but also for the sending state, if you will, the state that's using these sanctions. And so just from the target state perspective, obviously there's loss of commerce, there's adverse effect on civilians in terms of lost jobs and economic hardship. But in terms of the implications for Canada, and for any country imposing sanctions, that includes, therefore, also foregone business opportunities for our firms. That can have lasting effects insofar as a target state could implement import substitution measures. It creates restrictions in terms of what Canadians can do in terms of remittances, and we know that remittances are important flows between Canada and other countries. And of course, there's exposure to retaliation by the other country. With respect to the private sector, obviously, the more their economic ties are deep, the more the potential for lost business and investment exists. And in addition to that, you could say that the navigating the compliance is also a higher implication for them. As the committee heard from a number of witnesses, there is some evidence out there in terms of some of the academic journals in terms of chilling effects on trade and investment, and that's because firms, banks in particular, might take more of a cautious approach to compliance. So from that perspective, when it comes to using this measure, these are reasons why we look at this as a last resort, that we use it as a complement to a series of other diplomatic measures that would be deployed at the same time. In terms of how we balance, I think your second part of your question, which is how do we balance the issue of the implications for Canada? We'll look at a range of information, and as you heard, whether that's open source or classified information, that enables us to balance the foreign policy objectives associated with the use of the sanctions with the implications for Canadian stakeholders, for the Canadian businesses and Canadians more generally. These include the actions of our allies of the UN, the scope and severity of the offending state's actions, the impact of other diplomatic engagement actions to persuade a change in behavior, and the possible impact sanctions, of course, would have on Canadian firms and citizens. And in doing so, we'll take a look at not only what our people say on the ground and what our allies say, but obviously also what other departments would say and might inform our decision-making on. So that's a very sort of theoretical, high-level answer. But in the end, in every one of these instances, and I think the opening remarks and some of the answers speak to this, at the end of the day, it depends on who you're targeting and the context within which you're targeting them. So generally speaking, though, I mean, we stay at a fairly high level. We tend to not get into the details of how we would do that, obviously because the details of our approach we'd like to preserve the integrity of, and very much deal with these issues behind closed doors, if you will.
Please.
So just as a first question, we're seeing in multilateral organizations like the UN a lack of ability to necessarily implement sanctions. We can use Russia as a prime example around what's going on in Syria. Do you feel that given the new realities, and we see it with the ICC as well, of a weakening of some of these institutions in terms of being able to build consensus and implement things in a kind of global way, is this a reason that Canada needs to shift its sanctions regime? We've heard testimony that the bulk of our sanctions have come in through the UN. Does this point to a need to work maybe more individually with like-minded countries outside of some of the multilaterals? Does anybody want to maybe take a stab at that?
Let me make a couple of preliminary points before handing it over. I mean, obviously that the sanctions that are passed by the UN Security Council obviously have the agreement of the members of the Security Council, including the permanent members. That happens in a context. Those are then implemented under the UN Act. If the situation under consideration involves one of the UN Security Council's permanent members, obviously we're in a different political context. But I think that's where the government has other instruments available to it to take action. And that's where, as Hugh has set out before, there's CIMA has been used in those kinds of contexts. So that's where we look at the suite of tools that have been used to deal with particular contexts. Hugh?
Yeah, I would just add that, I mean, Canada, similar to all of our allies, have autonomous sanction regimes. So we work through the UN system, and when for various reasons there's a gridlock, there's an inability to pass a sanction through that fora, we have each of us instruments to do that. CIMA is the Canadian version. In all of these cases, we can collectively impose sanctions in response to threats to international peace and security, and we do that either in other countries or in Canada through the statutes or through regulations. Now that said, when I take a look at what other countries have on the books and their practice, the approach is highly congruent with ours, and in fact their practice reinforces a lot of what you've heard in terms of witnesses, including from us, but also from experts from around the world, which is the harmonized approach to using these sanctions is key. Taking a universal approach is essential because it's the weak links in the chain that create the dilemma of the effectiveness of those sanctions. And so within that context, and because of the severity of the measure, I mean, absent war, this is basically putting restrictions on what are very legitimate activities, and that's why I say collectively, Canada and allies tend to look at these as last resorts with high thresholds, and generally speaking, judicially reviewable measures as well. So I'd stop there, but just to say that I think Canadian practice is highly congruent with that of our allies.
If I can just add
Sure.
to North Korea, I think that's an interesting example of the use of both UN Security Council sanctions and CIMA sanctions under the CIMA because of differing circumstances. I mean, obviously, as colleagues said, the ideal is a situation as we have with the various UN Security Council resolutions where the international community as a whole all comes together in a unified way because of the very deep level of concern around North Korean nuclear tests. But then we had the situation with the sinking of the Chonan where it was more difficult to get universal agreement on the outcome of that study. And so there was a situation where a number of countries, including Canada, felt that there had been a very grave breach, but we weren't able to get that consolidated view within a UN Security Council setting. So in that instance, it was very useful to have CIMA as a way to implement further sanctions.
If we can move to Iran for a second, I mean, in your brief, you do mention the P5+1 and the compliance level that's been attained and the resulting elimination of a number of sanctions. Minister Dion himself said our eyes are wide open to the situation in Iran beyond just the nuclear issue to issues of human rights abuses and I mean things like execution rates and treatment of LBGT, state sponsor of terror, etc. Do you feel that within our current sanctions regime we have the tools available to deal with some of those gross human rights abuses? What's your feeling on where we're positioned now in this sort of delicate balance of having a country that to some extent is meeting its requirements as stipulated by the P5+1, but also where, again, as a country, as a government, we've identified that there's some core concerns to how they behave in the international arena?
So a couple of parts to that question. First, with respect to the implementation of the JCPOA, obviously the IAEA, headquartered in Vienna, is working very, very hard on this, and Canada, as the Canadian delegation there, is among those keeping a very close watch on what's happening in that context, and I addressed some of that in my opening statement. There's a very, very, very tight review of the implementation of the JCPOA. With respect to other other reasons why we are keeping a close watch on Iranian activity, there are other vehicles through which the government pursues its policy. With respect to human rights, the committee will no doubt be familiar with the resolution at the UN General Assembly on human rights that Canada led, passed last week through the committee stage, which is another vehicle of reflecting Canadian and the international community's views on the Iranian human rights record. There are other legislative provisions as well that bear on this. The IRPA, the Immigration Refugee Protection Act, provides vehicles for admissibility of certain individuals, certain backgrounds into Canada, and those kinds of things also come into play in this context when you're looking at the suite of tools that the government has available to it to deal with this issue.
Yeah, I might add that, I mean, it's important to note that CIMA, the current legislation, can allow sanctions in relation to human rights violations. And as we've mentioned previously, that's either where one of the organizations or association of states that we're party to calls upon its membership to take action, or where the Governor and Council deems that there's a serious breach of international peace and security which has or may result in an international crisis. We also impose, and I would add, it's not a theoretical construct. We've done so in the case of Burma, Zimbabwe, and Syria. Canada also imposes UN sanctions through the UN Act, which may include sanctions for violations relating to human rights. Now, should consideration be given to amending CETA to include an explicit human rights justification, there are a number of considerations that would need to be examined. For example, what specific circumstances would warrant a sanction? in response to human rights violations, and what would be the implications of such a mechanism if it were to be used, whether that's, for example, from a diplomatic, an operational, legal, and other, including for the public. Human rights is a broad concept.
Thank you.
Very much, Mr. Levitt. Before we go to Mr. Howson, we may as well get to the question in a formal way. Does the Order in Council allow for individual sanctions as it relates to gross human rights violations?
Well, as I just mentioned, I think the short answer is CIMA, as currently structured, does enable sanctions to be taken when the two tests, if you will, the thresholds have been met. And under those conditions, sanctions can be taken for human rights related situations. As I mentioned, that existed in the case of Zimbabwe, Burma, and Syria just more recently.
But again, go back to the question. Those are entities, states, and those are easily defined, that they could and should be considered a security, and that would make some sense. But to have an individual sanctioned from whatever country based on a human rights violation, that would not meet the test of that particular definition under CIMA, correct?
What CIMA currently enables you to do, you being the Government of Canada, is to identify a state, and you can actually, as the regulations and as mentioned in some of the examples, you can identify individuals under those regulations. So there's nothing in the current legal construct precluding you from identifying individuals, whether because of the actions that they play as agents of the state, of a foreign state, or because of their associated nature to some form of violation that the Governor and Council has deemed to meet the tests.
Okay, just for this, for the sense of getting to this issue a little more in depth. So, what was the human rights violations that brought in the sanctions for Burma?
That is a very good question, and I'm looking at Hugh to see whether or not he might.
I'll have to look at my notes, Chair. Burma's a while since those ones were put in place, but there would have been at the time concern that the situation was of such a magnitude that it was a grave breach of international peace and security, and that would have been the rationale for imposing sanctions in the case of Burma.
And if memory serves, it had sorry, we'll come back to you in writing, Chair. But if memory serves, there was a significant human rights dimension in the form of internally displaced and internationally displaced people.
Can I?
Sure, go ahead.
Yeah, just because we studied it in our subcommittee on international human rights. It was the Rohingya and the treatment of the Rohingya in Myanmar and Burma.
Okay.
Thank you.
So maybe what would be useful for the committee, from a hypothetical point of view, if we were to sanction an individual for human rights violations in the country of Russia, how would we go about it procedurally under the CIMA that's presently structured, so that we can better understand the laws that we do have, and because there is a strong sense by the committee that we do not have, as a government, the powers to sanction individuals for gross human rights violations under CIMA, or obviously FACTFOA is not part of that. But we do understand the United Nations Act and how it functions. But if that's not correct, it would be very important for you to correct the record for all of us here.
So perhaps I can do my best to try to assist, and again without trying to be too specific. But as Mark-Yves was saying, the tool that is available to the government under the Special Economic Measures Act essentially has the two different, we call them triggers, the two different triggers. One is the association of states of which we're a member. And that really is quite broad. That could potentially be used in a number of different circumstances as long as it's an association that Canada is part of that has agreed that it's appropriate to impose sanctions. As I was saying, that was the case with former Yugoslavia. That was a G7 statement or resolution that was done at the time. The second trigger is the one that's probably most are familiar with. That is the grave breach of international peace and security. And there can be situations of gross violations of human rights that might be such that it would be considered by the Governor and Council to be a grave breach of international peace and security. And that was the case in Burma. It was the case with Syria as well, and Zimbabwe was the other situation. So it's very much, I guess, a contextual analysis. It depends on the circumstances and the circumstances that the Governor and Council views as being sufficient to be considered a grave breach of international peace and security. But under that second trigger, if you meet that threshold, it could very well be a situation of gross violations of human rights that might lead you to that particular conclusion. It's contextual. It's going to depend on the situation.
Okay.
I would add, and I'm trying to think why you're asking this question the way that you're asking it, and it may be, in my mind, that a point of confusion, insofar as what you may be asking is, can we target individuals, and that is only individuals, as opposed to targeting a state and then individuals? The current legal construct is that you identify the state as well as individuals.
That's right. And then we'll go to simplify it even further, that the U.S. has brought in the Magnitsky Act with the objective of dealing with individuals, not the states and or with the UN and the Security Council structure that we are very familiar with. So the question we're asking is, if we broaden it to individuals, does the legislation allow us to do that now? And if not, then obviously there is a need to rethink if we are going to recommend that or change that as a government. So we're trying to get a sense of how we would do that under the present structure. So I just leave it for that for now, and we'll let some of the other committee members ask some questions. But I was just trying to get to the point of, because you made it sound a little earlier that in fact we do have the legislative structure in place to do it, and that certainly has not been the case of anyone who's come to the committee so far. So I'll turn it over to Mr. Allison for the continuation.
Well, thank you, Mr. Chair. As a matter of fact, I was going to continue along this line anyway, so you asked half my question, so I'll just keep going from there. But I do want to ask that then. What is it that we could do? Do we need to try and broaden it out and look at if that was the case? Because it would seem instead of the recommendation isn't a whole new piece of legislation that sort of stands alone and we have to fit in somewhere, that we broaden the recommendations in CIMA. So my question would be, is there a way then that we could, instead of looking at the countries or the gross, we could look at something from an individual point of view? Would that make some sense, and would CIMA would be the most logical place for it to stand if that was the case?
You're basically asking us for advice as to how we should amend the Act. And I don't know that we're in a position to do that. I think, given our roles as public servants, we're here to explain sort of the facts as they exist in terms of as they currently are. I think, as I mentioned a moment ago, individuals are listed under the current CIMA. They are done so only once the country that is deemed to be an offending state, if I can put it that way, has been identified as well under the Act. And that's what our current statutes enable us to do. Has that been used in the context of human rights violations? Absolutely. I mentioned 3.
Sure, and I think as well, I mean, one of the other things that was said through testimony is that it's, maybe we should be looking at that from a global perspective, not just targeting certain countries, so as we might do. And so I guess what I'm hearing you say is that although it does provide the opportunity, maybe it's sufficiently vague in that it's hard to do at this point in time, and maybe one of the suggestions is that we look at a way to make it more definitive. And I think, would that be helpful then, is that we made some recommendations in terms of trying to be more definitive under CIMA?
Yeah, perhaps an observation of what's going on or has gone on south of the border. Obviously, you're talking about a Magnitsky Act in the United States. They have an act called the Magnitsky Act. What's interesting in its application is that it has been met with retaliation that you might characterize as being of a surprising nature. The Russians went after, of all things, a class of individuals in the United States, parents trying to adopt young children. They basically retaliated in what I would call a delinked and surprising manner. There are implications to that. The other observation I would make is that there are statutes in play in the U.S. Congress to actually modify the Magnitsky Act. So without characterizing what they feel to be their experience with that statute, clearly there's action being taken south of the border to evolve that statute. Where that ends up remains to be seen.
Sure, and I think one of the things we did here is that we should at least make it global in nature versus just trying to target specific countries that may have that issue. I guess the other thing that, maybe one last question I would have then is in terms of, you indicated, and we understand either RCMP or other charges. We've seen that there's been only one successful charge since '92 under CIMA. So in terms of trying to enforce any of these things, I mean, we're also looking for recommendation as well. It always seems that, and I understand silos, certain departments have certain responsibilities, because I think one of the things that was said to us is that, well, that may not have any effect because are people really going to put money in Canada, et cetera, et cetera. It's nothing's happened. There's been no charges, et cetera. Yet there's an article written by Mr. LeBlanc, and it talked about the fact that with some investigation going on, and I realize that does this go back to resources again in terms of looking, how is it that we can actually find out if people are abusing or not doing what they're supposed to do if we don't tie resources? And if that's one of the recommendations as well, then maybe that's something we also need to look at, is that it seems that when we introduce legislation, it's for a moment in time, and then we don't go back to it again unless it's relevant or we seem to forget about it. So I guess my question to you up there is, as we look at, and it was talked about before, the resource piece, is that one of the also the missing elements in how we try and make some of these sanctions more effective, or have them stick, or have them have meaning?
Yeah, I think from my perspective, you mentioned that other departments and agencies have key roles to play on the enforcement side, the RCMP, CBSA, and so forth. I don't know that we're the best placed to comment, or that it would be appropriate for us to comment in terms of their resourcing levels. That's the expenditure management system, being what it is in Canada, involves a number of players. But that said, we obviously have faith in our colleagues in these other organizations to prioritize resources as appropriate to meet the priorities and the challenges that this country faces.
Senator, we'll go to Mr. Fragaskatos, please.
Thank you very much, Mr. Chair. Ms. Leclerc, you said something earlier that I found quite striking. I quoted you here. Whenever you do something, you're talking about states, whenever you do something, you can certainly expect a response. So state A takes an action towards state B is going to respond. I think of that, and I think of regime types. I think of authoritarian states and how they might respond, because the way that they will respond will be dictated by the nature of the regime, the nature of the political culture in that regime, the nature of the leadership. This committee has heard testimony from a number of experts. Last week I mentioned Kim Richard Nossel, who's one of the foremost experts in Canada on sanctions legislation. This week I want to talk about Daniel Drezner, who's based in the United States at Tufts University. He told this committee, and he's a widely recognized expert as well, he told this committee, quote, "Usually the authoritarian state, when sanctions are imposed, usually the authoritarian state becomes even more authoritarian in nature in response to any sort of external acts of economic coercion." Economic coercion meaning, of course, sanctions. I read that quote and I think of the proposed Magnitsky Act that's been tabled as a private member's bill and has been the subject of much debate. If Canada was to enact a Magnitsky Act of the type that's been suggested, then doesn't that give carte blanche, or if not carte blanche, doesn't that open up the door to a particularly to a very difficult response from a human rights perspective? Doesn't that allow Russia to take actions that would go contrary to very basic democratic principles, that would lead to human rights abuses getting even worse in a state like Russia?
Okay, so thank you for that question, which I think ended in a different place than I was expecting. So you're talking about, when I referred to a response, I was referring to a response directed at the country imposing the sanction. So if when we impose the sanctions on Russia, there is a response directed at Canada. And Mark-Yves gave the example of the what happened in the U.S. with their Magnitsky Act, what happened with the...
Whether the response is directed to Canada or whether the response is directed to Russian citizens, there will be a response either way. And I want to ask you and any member of those testifying with knowledge of Russia, if Canada was to enact a Magnitsky Act, wouldn't Russia respond, simply because of the nature of the regime, in a way that goes contrary to what we would hope for? Wouldn't the human rights situation get even worse?
Let me field this one, perhaps. I mean, we're well aware, as you are, that there is legislation moving through Parliament that ostensibly acts upon, which mirrors a lot of the attributes of the U.S. Magnitsky Act, and the government has yet to pronounce itself publicly on statutes such as those. I'm thinking in particular of S226, where the government continues to consider its position on S226. So it would perhaps prejudicial for us to comment and speculate in that context of this nature.
Okay, I'm just trying to take advantage of your expertise, because I think that if Canada was to put in place a Magnitsky Act, based on the testimony that we've heard from a number of academics, namely Kim Nossel, Canada's leading expert, and Mr. Dresner, one of the leading experts in the United States, if not the leading expert when it comes to sanctions, that those who are concerned about human rights violations in Russia would be even more concerned, because Russia would respond by violating human rights even further as a retaliatory measure to the international community. In this case, Canada. At least that's plausible. That's what the evidence would suggest. Another question here. The Targeted Sanctions Consortium has found that sanctions achieve their stated goal less than 30% of the time. With that in mind, I think it's fair to say, at least from my perspective, that sanctions are at best a tool, one tool in the toolkit, so to speak. What other tools do we have to address activities of concern? Human rights violations, or other issues of concern, the development of ballistic missile technology, or to encourage even changes in behavior, having a state withdraw from a particular area that it shouldn't have been in the first place. Yeah, I think you know what I'm talking about. But, speak to that, please, because I think that there's, while sanctions are an important mechanism to enact, I think there is a great deal of faith placed in their ability to suddenly, with a magic wand, change a situation. And sanctions are not magic wands, as this committee has heard.
Perhaps that's a question that several colleagues would wish to share on, but certainly there are a number of different tools that are available to a state to express its displeasure, and they include the usual diplomatic tools. They include things, I think the Iran resolution was mentioned today, for example, a resolution that Canada has led on at the United Nations for a number of years to condemn the human rights situation in Iran. They can include Security Council resolutions if you can get consensus amongst, at least amongst the permanent members of the Security Council. And I will turn to my colleagues to add to that list as well.
Sure, just a couple of other quick points. I mean, one of the things we haven't touched on today is the import-export control system in place. The Minister of Foreign Affairs obviously has authority over. There's a variety of other international fora, to use a lack of a better term, where there are conversations among like-minded states about proliferation-related activities, Missile Technology Control Regime, Australia Group, among others, all of which are designed for like-minded states to get together, to look at the problems they see in the world, and to identify ways in which they can help to reduce those problems through things like coordination on how we deal with exports of sensitive goods, or other forms of diplomatic pressure that can be placed to address the international peace and security issues that we are looking at. There are constant conversations about how to improve those processes to achieve better ends, but there's a lot of time spent on those processes as well.
One last question here, and it actually picks up on a point that the chair originally raised. Can you tell the committee what measures are in place to deal with take a specific situation, the abuse, torment, even murder of a human rights and democracy advocate? If that happens, what measures are in place for Canada to respond? How can Canada respond to that? For example, if the abuser and ultimately the murderer wishes to come to Canada, what can Canada do? If that abuser and murderer has assets in Canada, what can Canada do? Surely there is, tell the committee, surely there is existing legislation in place that allows us to address those concerns.
I'm going to start at the very beginning with the question of if the person comes to Canada. And I think one of the most immediate tools, of course, is the Immigration and Refugee Protection Act. That is the ability to prevent individuals from coming to Canada. And again, it's another department that would need to speak in detail to this, but there are provisions in the Act to prevent people from coming to Canada, to render them inadmissible because of violations of, I think the language is human or international rights. So that's, I think, one of the first aspects of the legislative framework. Depending on the circumstances, if you were talking about an individual and it's a situation where the country is already under sanctions under the Special Economic Measures Act. Again, we've talked about listings. Listings of individuals are possible under the Special Economic Measures Act as long as you've reached that threshold of it being a situation of a grave breach of international peace and security. For individuals who are responsible for wrongdoing in some manner or another, the usual processes of law are available as long as you can make the necessary connections to Canadian jurisdiction. And that would be a question, I think, better put to the Department of Justice. And as I say, I do know that one of the questions that came from the chair was to get a sense from the Department of Justice of the range of legal instruments that might be available.
Thank you, Mr. Fragascatos. Mr. Kamiec, Tom, you up? Mm-hmm.
So thank you again for coming in today. I just want to focus at the start here on page 11 of your notes. It talks about sanctions in each case where an exemption to the regulations is requested. So on humanitarian grounds, I guess someone can make an application for the non-imposition of sanctions. Can you explain how that request is made and who can make a request?
Sure. Basically, any Canadian organization or individual can make a request, and the case here is in relation to North Korea. So any individual or organization who wanted, for whatever reason, to export to North Korea or to have some financial transaction or any other activity that's precluded, could apply to the government through our department to make that request, and then we look at these on a case-by-case basis. So we would look at each individual request to see what's being proposed and whether we think that matches with the allowed exemptions under the Act and the regulations. So if, for example, it seemed like these were genuinely goods that would be primarily humanitarian in nature, for North Korea in particular, we're looking also at questions of the possibility of diversion, because one of the concerns is whether anything that you're exporting could be diverted to use by, say, the military or the government. So we're looking at, again, case by case, the nature of what is being proposed, and then if it seems to be acceptable on humanitarian grounds, then an exemption would be granted.
And so who makes the final decision? Does the minister have the final decision-making authority for the exemption, or is it cabinet?
It's the minister.
It's the minister who makes it for the exemption. Okay. And you said any organization, any individual Canadian can also make the request through the minister to the department?
As far as I know, I don't think there's any, there's no particular restriction on who could.
And how many of these types of exemptions have been granted for the DPRK, for instance?
12. There have been 12 since the regulations were put in place.
And these were Canadians or NGOs, or were they some other types of organizations?
I can't give you too much detail on them because the individual requests are private, because in some instances there might be commercial considerations. But I'd say in almost all instances these are around humanitarian goods. And yes, in most cases we were talking about organizations that were involved in humanitarian assistance in North Korea.
Okay, so this committee has heard from Professor Charon that some of the unintended consequences of more punishing measures would only harm innocent civilians. And the professor was saying that when it comes to Russia, Syria, Zimbabwe, some other countries, that the policy calculations of their leaders there in the regime, they don't take into account Canadian sanctions, whether multilateral or unilateral sanctions. But we heard from Andrei Sanikov, who was an opposition leader in Belarus, that is the case, that prison guards, prison administrators, people who actually carry out the orders of the political leadership do take into account. And what they don't want to see is their names pop up on a sanction list. So does any of that come into the calculation of the department when you make a recommendation to the minister on whether or not to levy the sanctions? Is that kind of the coercion, not on so much the political leadership, but on the people carrying out the orders to oppress political leaders, to oppress human rights activists, to oppress NGOs?
Happy to take that. Sure. I guess the current practice, our current approach to sanctions reflects a significant evolution that, in terms of learning over the past 25 years. It used to be that state practice was, looked at embargoes, basically sanctions being a rather blunt instrument. The main driver behind the shift away from using sanctions as a blunt instrument was basically humanitarian considerations, that we're potentially harming, vast populations, as opposed to shifting state behavior in a more targeted manner or through a more targeted approach. So the practice today, international practice today, and I think you've heard this from various witnesses, including Dr. Thomas Biersteger, which basically, he's speaking to this notion that we've very much honed in on tailored messages and on decision makers and their associates in a specific country. I mean, that approach is meant to, is seen to be perhaps a more effective way to bring about that behavior that we're trying to shift, particularly in some of these countries.
If I can just interrupt you then, because I don't have a lot of time, then wouldn't that more selective approach on sanctions to target specific groups of people or individuals then avoid some of the harm that could be potentially made to a broader population? Something like the Magnitsky Act would then make sense, where you could specifically target groups of people, put them on a list, make it easy for businesses then to access the list so they know, prison administrators in these specific prisons are being targeted for sanctions in order to protect political opposition leaders, political prisoners, civic society in general, as a way to put pressure on the regime. So it's not to punish them, but it's to coerce them into either stopping their oppression, or it's to entice them into different actions. And of course, there's always that power consideration with large countries, superpowers, quasi-superpowers, and then smaller countries. But if we do it in tandem with our allies, wouldn't that make sense?
Yeah. If you take a look at what we've done, including in the Russia sanctions, for example, I mean, that is precisely what we've done. We've targeted individuals, decision makers, and their associates. We've done so because of learning over 25 years of application, which is to avoid harming broad populations and to focus it on targeted measures on decision makers and their associates. And this approach is not only good for the populations, it's also more effective in terms of operationalizing these sanctions insofar as we're mitigating the potential implications for third countries. And by mitigating the implications for third countries, we're therefore mitigating the desire to circumvent the sanctions. So from that perspective, the approach of targeted select measures, targeting individuals, decision makers, and their associates is very much the current practice.
Do I still have time, Mr. Chair? So I'd just like to move back to DPRK for a moment. In the notes, it mentioned that unilateral sanctions were imposed on them. So I'd just like to know those unilateral sanctions that Canada imposed that were later mostly copied in the United Nations Security Resolution, which I had noted, and now I can't find it here. Were they effective, those unilateral sanctions that Canada imposed? Have our sanctions been effective?
Yeah, so just to clarify maybe a little, so there have been a suite of UN Security Council resolutions and sanctions associated with those. With each resolution, we've then implemented measures under the UN Act, so we've been implementing that as they go along. Those all relate to non-proliferation concerns, basically. And I'd say on those, in terms of effectiveness, it's hard to separate out sort of the Canadian piece from the broader piece. And I think you'd have to look at how effective the UN sanction regime has been as a whole. But your main question was about the unilateral ones. So those were under CIMA. Those were in response to that specific incident, the sinking of the Chonan. And I'd say in purely commercial terms, quite effective. And we didn't have very much trade with North Korea to begin with, but it was in the order of about 26 million, I believe, pre-sanctions. It's now, I don't have the exact figure, but we'd be, under 1 million, I would imagine. I mean, our trade with North Korea has gone down to virtually nothing, again, outside of those small number of humanitarian exemptions. So that has been very effective. I'd also say, again, because our trade was so small before, that probably hasn't had a huge impact, material impact in North Korea, but some of the other measures, so relating to, for instance, financial transactions and transiting through Canadian ports, for example, those have perhaps had more significant impact. It's a little hard to measure those, but I'd say in terms of importance to North Korea economically, that those may have been more important.
Okay, thank you.
Thank you very much, Mr. Kimnich. We'll now go to Madame Laverdière.
Oui, merci beaucoup, Monsieur le Président.
Thank you, Mr. Chairman. Thank you. I'd like to take the opportunity of your presence here today to ask you this. There were 148 people of Egyptian origin placed on a list under FACFOA since 2011. And now, in 2016, there isn't one name there, nobody of Egyptian origin. So given that the situation in Egypt hasn't necessarily improved, I'm wondering why it is that there was no one from there left on the list.
Very much. The Freezing Assets of Corrupt Foreign Officials Act essentially is established in order to respond to a request from a foreign state. So it's the foreign state in the particular circumstances under the Act that makes the request to Canada to actually freeze those assets. and those lists expire after a period of time. And the reason that the Act is set up that way is because it's meant very much to be a temporary action. It's not meant to be a permanent seizure of the assets, but the idea behind the Act is that the foreign state will presumably make a request for mutual legal assistance. And again, it's the context of the Act itself that's important, I think. It was established really as a response to the events that have become described as the Arab Spring, and it was meant to deal with these situations of turmoil, of government change, and a concern of assets fleeing the jurisdictions. But it was never meant to be anything other than a temporary response. It is to support the foreign state. If the foreign state requests that the list be extended, it can be done. But if the foreign state does not wish for the list of names to be extended, then it comes to an end.
C'est ce qui expliquerait aussi que l'aide.
So that would also explain that the names of people of Tunisian origin went down from 123 to 8. Speaking of Tunisia, when there was a legal request to return funds to the state of Tunisia, if I remember correctly, I've got the figures somewhere, that happened a few years ago, Canada was envisaging keeping most of the funds and submitting only a small proportion to the Tunisian government. Is that standard practice?
Aware of the specific details. As I say, under the Freezing Asset of Corrupt Foreign Officials Act, it is very much meant to be a temporary measure to be followed by a request for mutual legal assistance, and whatever rules guide mutual legal assistance would then apply to how the assets are returned and the specifics of that.
S'il était possible de fournir au comité.
Would it be possible to provide those details to the committee? I think that would provide a good example of what happens in such cases. The request made by the Tunisian government, it was by Mr. Ben Ali, if I remember correctly. So what was returned to them exactly? If you could please provide as much information to the committee as possible in writing, it would be much appreciated. Thank you.
Okay.
Mendez, please.
Thank you
Final
very much,
question.
Mr. Chair, and I'm just a guest here at the committee. I'm also very involved with the Commonwealth Test, so I'd like to ask a question of another jurisdiction, and that would be the UK, where there have been quite a few attempts in the courts to overturn sanctions, and the application of sanctions being considered unconstitutional, even when required by the Security Council, and mainly the grounds are a lack of due course. Is this something that we are afraid would happen here in Canada? Is that something that there is a possibility of happening here in Canada?
I suppose as a general answer, anybody who's affected by an aspect of Canadian law could always seek to challenge their listing under Canadian law and seek judicial review for a variety of different reasons. That's always certainly a possibility, which is why we try very hard when we're adopting regulations and making recommendations to ensure that we have good information on which to base those listings, is to protect them from challenges that might otherwise be brought.
Haven't had any instances of challenges to due course in Canada at all for the application of sanctions?
We have not had any that have come to trial that I'm aware of.
Okay, that doesn't mean that we haven't had attempts.
That's right. That's right.
Okay. Thank you for the clarification. Can we have an idea of what kind of metrics you use to measure the effectiveness of sanctions? Because yes, I mean, personally, I could debate a long time about the use of sanctions. I think usually they do, that's a personal opinion, they do more harm to the population of the country targeted than in terms of changing the ways the state. But do we have any measures or any metrics that could be shared with committee about the effectiveness of sanctions?
I think you've heard from a number of witnesses that, there are competing views around the effectiveness. And what was interesting in the witnesses that have appeared in terms of the expert testimony that has been provided is that they each, I think, generally have had their own methodologies. So I think our sense is that, in terms of the recognition that the research varies and it's case dependent, we do our own assessments. We do our own assessments on a case-by-case basis and on an ongoing basis. But it's very difficult it's very difficult to isolate the merits of the sanction, given that they are deployed within the context of a broader diplomatic toolkit, negotiation, what have you. Our own sense is that they are most effective when imposed universally, and in order to ensure an optimal impact, as well as doing so in a manner that doesn't necessarily put Canadian interest at a disadvantage, commercial interest in particular. And our own sense as well is that it's, setting out a clear and specific objective for the sanction also helps to ensure the effectiveness, and that's generally done, as I was mentioning, as part of a broader suite of engagement tools, for no other reason than to provide the offending state the opportunity to adapt their behavior and therefore de-escalate the situation. Now, that said, whenever we cease using a sanction within the context of a relationship, we will publish. The Act, CIMA, requires us to publish or to issue a report, the Governor and Council to issue a report within 60 sitting days in terms of the operation of those sanctions. I've brought examples of that here today, and I'm happy to leave those behind. They give you a sense of the assessment that has been made in terms of their operationalization.
Should be interesting. I'm done, Mr. Chair. Thank you very much.
Mendez. One last question. We tend to, as a committee, focus most of our attention on CIMA. As you know, we're here speaking to you and doing an analysis based on the requirement under FACFOA for after 5 years, a review of its continuation or its amendment, or whether it meets the test of what Mr. Fragascatos has asked. Is it still a good tool for the Government of Canada to have at its disposal? And so it would be useful if you were willing to give us a sense of whether you see FACFOA as a piece of legislation that has met the need of the Government of Canada and would like to keep it in place for an extended period of time, whether it's another 5 years or whichever way we want to recommend this. But it was, as you mentioned, part of a response to the Arab Spring, and was intended to be, I think, as I understand it, a temporary measure. And so it would be useful if the Government of Canada and its officials would be willing to tell us whether they think it's a tool that you would like to see continue.
I think our experience with the Act to date has been that it has provided a tool that we lacked. It provided a tool that allowed us to respond to those very particular circumstances for which regulations were adopted. We know from some conversations with other states that they have looked at the Canadian legislation and found it, I think, to be interesting. I understand, for example, that Switzerland has legislation that is different, but in some elements is similar as well to the Canadian legislation. And as I say, what it does is it provides us with an instrument that we didn't otherwise have to respond to a very unique set of circumstances. So I think it, at least from our own experience, it has done so, and it has met those objectives, allowing for a state in a situation of some internal turmoil to reach out to try to prevent essentially asset flight by requesting a temporary freeze on assets, and to give that state time to organize itself enough to be able to make a more formal mutual legal assistance request.
Well, thank you very much. Appreciate that response. Now, colleagues, I want to take this opportunity to thank Mr. Glasser and his colleagues for coming before the committee as witnesses. It was a very productive couple hours, and we very much appreciate that. And thank you, and we would look forward to the responses that we did not get a chance to speak to that has been requested of you in writing, and look forward to those answers as well. So, Mr. Glasser, on behalf of the committee, I want to thank you very much for making your presentation as fulsome as it was.
Thank you very much.
Colleagues, I want to go into camera for like 5 minutes. That's all it'll take. I want to correct one little error that was made in the committee. And so with that, I'll take a 30-second timeout, and then we'll get right to it. So please don't go too far.